Iwata Sensei, can you see the screen? Is it sharing properly?
Yes.
Excellent. Thank you everyone for attending our second Japan business seminar. Our first topic was on accounting, which we had a licensed CPA from Matchpoint Accounting, and I'll send the link in the follow-up email. This session will be recorded. And for today, we have Iwata Sensei, who's going to talk about Japanese labor law. So Iwata Sensei?
Yeah.
Could you please give a short self-introduction, please?
Okay. I am Kyoko Iwata from Iwata Labor Management Office in Nagoya. I am a labor and social security attorney, generally known as Sharoushi in Japanese. Currently, I receive various inquiries regarding labor and social insurance matters from employers of small and medium-sized enterprises. Labor laws in Japan are very complicated and difficult to understand, even for Japanese employers. The examples of the consultations I received recently, for instance, are how to deal with employees who are in trouble, or how to set a fair salary in order to realize equal pay for equal work, and so on. Rules of employment is absolutely necessary in order to avoid troubles as well as to cope with troubles which already happened. Things will go against employers when troubles occur in the absence of well-established work rules. We are currently supporting employers with the creation of such rules of employment. Thank you.
And Iwata Sensei also has 17 years of experience, and she'll also clarify in some situations that what it's better to talk to a Sharoushi about or with a lawyer about, because there's a difference between the two.
Yes.
And as for myself, my name is Tyson Batino. I co-founded an English chain called One Coin English with a couple other fellows, and we grew it to about 8,000 active students, 11 schools, and over 200 staff in 6 years. And I also founded a company called Japan Switch. And right now I'm helping entrepreneurs to 2x, 5x their revenue year over year based on my experiences of scaling One Coin English to, I'll say, mid-sized company. Have a lot of satisfied customers in various industries, language schools, marketing agencies, software companies, and you name it. So let's dive into Japanese labor law. So this was actually the most common question we got. So this person asked, I hire a lot of freelancers. What is the difference between contract workers versus company employees? And their second question was, can I provide contract workers with some benefits? So I think there's 4 questions with the same format. One person asked, what is Gyomui Taku? Another person asked, are there any regulations for freelancers contracts in Japan? And the other one was, what are things that a company should pay attention to while working with temporary contractors in terms of labor law? So I think all 4 of these questions bring up the same topic: is what is the difference between someone who is, I would say, kind of like Gyomui Taku, where freelance contractors, where you're outsourcing work to them, versus an actual company employee. And Iwata Sensei, could you please help explain?
Yes. Since I have received several questions regarding a worker and contractor, I would like to explain the difference between a worker and a contractor. I believe terms such as freelancer or gyoumu itaku mean the same thing as an independent contractor. Let me explain what an independent contractor first. It boils down that you should actually beware of the following points when you are concluding a service contract with an independent contractor. 1. You must set a service providing contract which stipulates various conditions such as business content, payment method, deadline, etc. at the time of outsourcing. 2. You should not give command or supervise them. Make them be able to select the work method and procedure at their own discretion for the work. 3. You cannot set everyday biding time for them. They only need to meet the deadline. 4. The payment should be based on a complete piece rate payment method, not in the form of wage evaluated by labor service provided in a certain period of time. 5. They must not be objected to enroll in social insurance and labor insurance. 6. Do not offer them tools and equipment for the work to be done.
Thanks
Okay,
for
okay.
and I think that's a lot of information for everyone. So let me just confirm.
Okay.
So I think so. One, it's so for example, if someone's on a Gilmore Taco contract or a freelancer, you cannot tell them you must work from 8 a.m. to like 12 p.m. Is that
No,
correct?
no, you
Gotcha.
cannot.
And the other one is after you've kind of set the agreement, you cannot supervise them or like give them commands, right?
No,
Like
you
direct.
cannot. No, you cannot.
Okay. And the other one is, let's say if they need like a computer or something, since they're a freelancer, independent contractor, they have to provide their own tools and equipment themselves, right?
Yes, that's right.
Gotcha. And since they're not technically our employee, we cannot, let's say, kind of force them to roll into like social insurance or labor insurance.
No.
Thank you very much. And I think, and for everyone listening, it's if you do have questions, I'm not sure if we'll have time to get into it, but if you could type in when you ask a question, if you could refer to what question, we have about 10 questions we're going to cover, and if you could mention what question your question is about, that'll help us greatly in answering. Okay, next, Iwata Sensei, can you
Yes.
explain what a worker is?
Okay, let me explain what a worker is next. Okay, it's a bit difficult, but I will try. Article 9 in the Labor Standards Act stipulates the definition of workers as follows. Worker means one who is employed at a business or office and receives wages therefrom, regardless of the type of occupation. Employed here means that a worker is under command or supervision of an employer and ordered to do jobs under a labor contract for some designated hours and get payments as salary for the work they've done. The judgment criteria to be regarded as a worker are shown as follows in the Ministry of Health, Labor and Welfare webpage. I will call an independent contractor as a freelancer here. 1. Whether or not there is freedom to accept or reject work requests. For example, a freelancer can choose to accept to reject work requests, but an employee has to accept them. 2. Whether or not there is command or supervision in the business execution. This means whether or not commanded or supervised by an employer. For example, a freelancer can work without command or supervision from the person ordered, but an employee will work under the command or supervision of an employer. 3. Whether or not it has to offer service at a certain time slot designated by the employer. This means whether or not they are bound for a certain designated hours to work. For instance, a freelancer can work anytime and for any hours he or she wants to, whereas an employee has to work between the designated working hours. 4. Presence of substitutability. This means whether or not it is possible to change persons or to call a helping hand and have the substitute perform it or ask another person to help without obtaining the consent of the ordering party, etc. For example, a freelancer is free to make someone help his or her jobs, or even make someone substitute him or her in doing stipulated jobs at his or her discretion, because the goal is to provide the service. However, employees cannot ask someone to substitute for their labor at their discretion under a labor contract. 5. Burden of machines and equipment. Employers have to have the burden to provide equipment for workers, while freelancers have to provide it themselves. 6. Amount of remuneration. For example, the amount of calculation of remuneration for a freelancer should be based upon piece rate payment and shouldn't be similar that of a salary for employees. I will ask the question, can I provide the contract worker with some benefits here? The answer is no. In a Gyomu Itaku contract, you will determine the fee which will be paid by completing a certain amount and quality of work, or by providing a certain amount and quality service by the defined term. No other payment than the fee determined in the contract should be paid. If you pay hourly wages or overtime payment for a freelancer, it will increase the risk of being sued as a disguised freelancer. 7. Degree of exclusive attribute. For example, a freelancer can work with other companies at its own will. These are the criteria for discriminating a worker from an independent contractor.
Gotcha. So for point number 7, I think, let's say a freelancer can work for another company, but let's say if I'm employing someone, I can write into the contract that they cannot work for another employer, right?
Yeah.
Gotcha. Also for employees, companies are responsible for providing like the machines, the tools, equipment for them to carry out their work.
That's right.
And yes, for like someone on a freelancer like Gyomu Itaku, let's see, it's like technically you're not allowed to pay them hourly wages, right?
No.
And I think also it's I know it's not 100%, but in general, an employee does have to accept a work request, while a freelancer can say yes or no.
That's right.
Thank you very much. And I think also for employees, employers can set a defined working time. Like for example, let's say 9 a.m. to 5 p.m.
Yes, in the labor contract, you have to set the prescribed working hours for a day or for a month and
Gotcha. So it has to be gotcha. So the working hours must be included in the contract, right?
yes.
Thank you for confirming that.
Okay, so I will go on.
Yes, and thanks for the question, Joe. I'll give Iwata Sensei some time to look at that question
Yes.
when I talk on my part a little bit later. But Iwata Sensei, please continue to question number 2.
Number one, the rest. Can I proceed to number 1, rest?
Yes, so move on
Okay,
to...
okay. I want to add something here that, yes, I want to introduce an article here regarding a worker and a freelancer. It is from the morning edition of the Chunichi Shimbun on June 14th. The title of the article is Amazon Delivery Workers Based in Kanagawa Prefecture Formed a Union of 10 people claiming Gyomu Itaku being disguised. This is about freelancer and worker conflict. 10 delivery drivers who have concluded Gyomu Itaku contract with the subcontractors of Amazon Japan formed a union, the Tokyo Union Amazon Delivery Workers Union Yokosuka branch. The union members work as a sole freelancer, but they claim that the outsourcing is camouflage because they receive commands and orders from Amazon through apps, and their working hours are managed. They argue that they are supposed to be workers under the Labor Standards Act. Amazon delivers products all over the country, and there are many delivery drivers who work in the same way as these members. Since last year, Amazon has implemented a system to determine a number of packages and delivery destinations for each delivery person by artificial intelligence, and the number of items to be carried has increased sharply as a result. Amazon Japan says that the delivery person is not required to use the app. Okay.
So I think that actually, I think that kind of answers Peter's question. So I added the link in the chat notes, but sorry, for Amazon, were they having people on an hourly rate or they're giving people schedules?
Oh, there. I don't. I haven't. Get the information about that. But all I can say from this article is they are commanding or supervising them by the app, and
I
also
see.
they are doing some time management. I don't know what it is, but
Gotcha, specifically. Cool. No, thank you for sending that. And I added an article which does not have a paywall in the chat. And actually, I want to ask you, Iwata Sensei, would you like to answer Joe's question?
Joe's question.
It's in the chat. It says, so I think it's, wait, yes, I think,
Cannot pay hourly wages to freelancer.
yes. So
So
his
that means
confirmation is they have
yes,
to be on a
yes.
fixed contract rate or a project rate.
Oh, this depends on the what type of contract you're concluding. That's because there are some times for Gyomu Itaku, which is which purposes of which purposes the compression of the work. So in that case, you are paying for the compression of the work, or another Gyomu Itaku type is providing service. So if you're providing service, you're paying for the service itself. So it depends on the type of the contract, but you cannot pay hourly wage for the contractor.
Gotcha. Thank you very much. Okay, and we'll move on to the next question. So, does Japanese labor laws require physically signed contracts when the employee is living abroad? So, I think in this case, they probably have some employees working overseas. And how are the salary and taxes handled in this case?
Okay. The answer is yes. When a company in Japan employs an overseas resident as a remote worker and the salary is directly paid from the entity in Japan. But to make it clearer, I will first explain what the Labor Standards Act stipulates regarding the indication of labor conditions. When employing an employee, regardless of its nationality or residence, you have to clearly indicate wages, working hours, and other working conditions stipulated by the Labor Standards Act by giving him or her a document containing such working conditions. This indication of labor conditions doesn't always have to be a form of contract, but has to be in writing. You can download the format of Notice of Employment from Ministry of Health, Labor and Welfare, which covers all the necessary items for the indication. It is also possible to incorporate the function of the notice into the contract and make it into one format. Also, you can issue a rules of employment to employees as long as the working conditions are specifically stipulated in it, clarifying the part applicable to them. The Labor Standards Act says that in the event that the working conditions that are clearly indicated differ from the actual fact, the worker may immediately cancel the contract. Okay, the latter part of the question, how the salary and tax processes and handled if the employee is living abroad. Tyson-san, can you please show the table here? Okay. Not that one, but can you hear me, Tyson-san? You're muted.
Yes, I can hear you. You're fine.
Right. Okay. So, Tyson-san, could you show the table about the tax and social insurance industry accident compensation insurance? So I will so I will proceed. Okay. While he is ready. As for tax, I'm not a specialist in this field, so I recommend you to ask the tax accountant for details. But as far as I recognize, though, the calculation rate for income tax for non-residents is 20.42%.
I was able to, yes, it's now sharing.
Okay. And I would like to explain here about the enrollment of each social insurance and industrial accidental compensation insurance and how to handle such insurances. For social insurance, I recommend you to talk to a Sharoushi directory because it can be complex depending on your contract type and work situation of the remote worker and the country they live in.
Gotcha, because I think each country has different agreements with Japan, right?
Yes, social insurance agreement, and it differs country by country. Okay, and as for industrial accident compensation insurance, the employee remotely working outside Japan is treated completely the same as the one working in Japan. Note,
sorry. After you finish, could you mention what it is in Japanese as well?
Oh, yes.
I mean, I think many of the listeners, they might understand the term better in Japanese than English.
Okay.
So, but please continue.
Okay. The case is different for the employees dispatched from a Japanese company to a company overseas. So this is only for the case that you are employing a person and they're working from overseas remotely. And those working only outside Japan do not have to enroll in employment insurance. This is the difference between the labor industry accident compensation insurance and employment insurance. So as for the industrial accident compensation insurance, all the employees, even for workers who work only one day a year, they have to be secured by industrial accident compensation insurance. So that's the norm.
Oh, that was scary. But is everything okay?
Yes, yeah.
Okay. Please continue.
Okay. And question number 3.
Oh, gotcha. So it's so employment insurance means koyo hoken?
Yes.
What is industrial accident compensation insurance in Japanese?
In Japanese, it is rosai hoken.
Gotcha. And
Uh.
social insurance is shakai hoken?
Yes, Chakai Hoken, which includes health insurance and Kosei Nenkin, which is pension, welfare pension.
Yes, I think it is employment. It's yeah, and tax I think is shotokuzei. Okay, and yes, let's move on to slide number 3. What am I required to do by law for part-time and irregular workers?
Okay, so we are not sure what you mean by irregular workers, as it is not a legal term. But here is what you're required to for part-time workers. 1. All workers, including a part-time employee, must be secured by industrial accident compensation, just as I mentioned before. And 2, a part-time employee working over 20 hours a week and will be continuously employed for more than 31 days, needs to be enrolled in employment insurance, koyo hoken. 3, a part-time employee whose prescribed working hours per week and working days per month are more than 3/4 of regular workers. Regular workers here means that the full-time workers in your company need to be in Shakai Hoken, the social insurance system.
So that means if the full-time employees are working 40 hours a week, any part-time employees working 3/4, so 30 hours a week,
Yes, that's
they
right.
would have to be enrolled into Shakai Hoken, right?
Yeah, so it depends on the full-time workers' working hours. It's less than 40 hours. It depends on the, you have to calculate it for 3/4 of it. Okay.
Thank you.
And the Japanese government is now trying to expand the enrollment application of Shakai Hoken for part-time workers. In October 2022, this year, those companies that employ more than 100 employees who have already enrolled in Shakai Hoken have to get their part-time workers to enroll in Shakai Hoken. And part-time workers here means those whose prescribed working hours per week is 20 hours or more. Those whose expected employment period is 2 months or more. Those whose monthly wage is 88,000 yen or more. And those who are not students. All those 4 conditions are met. You have to enroll them into Shakai Hoken.
So I think one of the participants might have over 100 employees. And so in their case, even if full-time is 40 hours, and let's say in this case, if they have more than 100 people, even if it's less than 3/4 of the schedule, if it's more than 20 hours, they still have to enroll the people into Shakai Hoken, right?
Yes, that's right.
Thank you.
And 4, you still need to give part-time employees annual paid leave, according to the working days and hours, which I will explain later. 5, you need to pay the minimum hourly wage given by each prefecture.
And I have one question. Do you need to pay transportation by law? Are you required to?
No, you don't.
And if employees pay on their own, is there any limits?
No, there aren't. Payment of transportation totally depends on each company. Of course, as most companies pay transportation allowance in the form of actual expenses, it may not work well for securing good personnel without paying transportation expenses.
Thank you. Thank you very much. And so I think several people also asked this question. I think this is actually probably the hardest question and the most nuanced question of all. But Do I need 4 write-ups before firing someone? So I guess what they're trying to ask is, how can I fire someone?
Okay. There are lots of rules you have to know before dismissing an employee. You may have heard that Japanese workers are protected by labor laws. Generally speaking, it is difficult for an employer in Japan to unilaterally terminate an employment contract against the will of an employee. To be precise, a unilateral termination by an employer is deemed to be an abuse of right and therefore null and void, unless such termination is based upon objectively reasonable grounds and is socially appropriate in light of the Employment Contract Act. I will raise 4 representative dismissal cases here. 1, physical or mental disability of workers unrelated to work. 2, extremely poor performance of workers. 3, infringement of internal disciplinary rules in the workplace by their serious misconduct. 4, redundancy of employees due to a bad economic situation of the company. For example, regarding extremely poor performance, objectively reasonable grounds means that a breach of contract arises and it is expected that such breach of contract should be repeated in the future. The employer has to persuade the judge at the judicial court, who doesn't have any knowledge about the subject employee, that the employee truly lacks performance with many pieces of evidence. Of course, an employer has to make their best effort to avoid a unilateral termination. There is no set number of warnings so far. For example, for 4, in some cases, may not show objectively reasonable grounds. In this case, we recommend talking to a lawyer who has expertise in labor law. Generally, a company takes step-by-step measures to terminate an employee, giving them reprimand notice as to how they are breaching the contract and how they should improve, getting letters of apology from them each time. So does the employee have to sign or agreement to the improvement plan? And the answer is yes. It is generally called the letter of apology. The employees have to sign up that they will improve their deeds.
What do you call that in Japanese? The letters of apology?
This is called sometimes I don't. I just don't.
I know it's more of an English term.
Yes.
Like performance improvement plan or
Improvement
PIP
plan.
is common.
Oh, really? Okay. So this is sorry, I just forgot the Japanese. When I remember it, I will mention it.
Okay, sorry about that.
So I think this is a ground for question 4 write-ups before firing a person, but to confirm, there is no set number of write-ups in law. So here's the procedure for dismissing a person through which a Sharoushi can help with. The employer will have to either give a 30-day advance notice or to pay the termination notification allowance corresponding to their salary, or a 30-day period based on a special calculation called average wage. And the number of days of notice may be reduced in the event the employer pays the average wage for each day by which the period is reduced. For example, the employer may give 20 days advance notice by paying an employee a sum of 10 days worth of its average wage.
So I wanted to summarize this one because I think every participant here will is pondering this question. So one big one is there's a Sharoushi, kind of like the labor expert, versus I would say maybe a labor attorney or an attorney who has an expertise in labor. And in terms of terminating a contract, this is something that you would normally discuss with an attorney. as opposed to a Sharoushi. A Sharoushi, Iwata Sensei, so a Sharoushi is someone who can help you with the paperwork, but the actual, if you can do it or not, is something someone should talk to an attorney with. Is that correct?
To be precise, Sharoushi can have some of the parts of the conflict, dissolving the conflict. But if you are if the things are go to the court, you have to ask the lawyer to help with you.
Thanks for clarifying that. So yeah, at the court, it would be the attorney. And I think the other one was, I know the law says something like, so I'm trying to find, I think it's let's say, a unilateral, so a termination, purely the decision of an employer can be deemed to be an abuse of rights, and therefore, let's say, the termination can be voided unless the termination is based objectively reasonable grounds and socially appropriate in the light of the Employment Contract Act. And if people wanted to look for more information, can they actually find what are very clear examples of reasonable grounds?
Reasonable grounds differ case by case, and you have to look for the case laws are accumulated in the past. So it is a very difficult matter, and you cannot say black or white for that thing. So you have to, if you are in trouble with some employee with these things, you have to ask a lawyer who is expertise in it.
Thank you for sharing. And I think I'm gonna try to. So for the people who joined our session, I'm gonna try to look for the link. I think JICA or one of the, or let's say they're not the legal department, but one of the Japanese departments. They have like a sample contract online, and I would just, let's say, we can't give you the exact case, but I would try to find that contract sample for you. And this is not legal advice, but I'll try to find the link. Okay, next one. Do paid working hours begin when the employee arrives at the workplace or when they are ready to begin work? So for example, if an employee needs to change clothes or put on makeup or other personal preparation, is this a paid task or the employee's responsibility?
Okay. Working hours can be defined as the hours during which a worker is providing labor under the command of the employer. Whether the time for changing clothes, gymnastics, cleaning, morning assembly, etc., which is performed before the start time, corresponds to working hours or not, depends on the indispensability and compulsion of the act. Let me explain it concretely. Regarding the time to change into uniforms before the start time at a company, a famous case law indicates that if 1, the company has ordered you to do it, and 2, you have to do it in-house, and in cases both 1 and 2 are fulfilled, it is regarded under the command of an employer. And as long as it is under the command of an employer, the time for changing clothes will be considered to be working hours. On the contrary, putting on makeup and other personal preparation, unless it is commanded by the employer to do so to fulfill their duties, will not be considered to be working hours.
Please are you finished with this question? Sorry, I'm looking for the contract sample.
Yes, I'm finished.
Okay. Thank you very much. And the next one is, so this was a unique question regarding COVID, but During a pandemic, is it reasonable to ask employees to submit body temperature daily if the employer provides the time and equipment for it?
Yes, it is, as long as it will be implemented during a pandemic. It is preferable from the viewpoint of obligation for safety not to expand the virus. However, should you reject their work only as a result of body temperature check, the leave allowance for absence from work will be necessary by the reason attributable to the employer. Labor Standards Act Article 26 stipulates that in the event of an absence from work for reasons attributable to the employer shall pay an allowance equal at least 60% of the worker's average wage to each worker concerning during such period of absence from work.
So let's say we do test the employees and they have, let's say, a fever or a high temperature.
Mm.
Can we make the employee use their annual paid leave or UQ?
UQ, annual paid leave, is the right of workers. If they agree with using their annual paid leave on those days, it is okay. But there are some workers who haven't got annual paid leave yet, or who ran out of their annual paid leave, or don't want to use their annual paid leave for such days. In such cases, the employer has to pay the leave of allowance apart from annual paid leave. It is stipulated by law that you have to pay a leave allowance equal to at least 60% of the worker's average wage if you make them take leaves by the reason attributable to the employer, just as I explained. However, if the employees who have high body temperature claim that they want to take a leave on the day by themselves, it will not be the reason attributable to the employer, and you won't have to pay the leave allowance for the absence.
I see. So if I say they take the temperature, they have a fever, and they say they want to take let's say they want to take a leave, then they could use their UQ. But yes, we can't force them to use it.
Mm-hmm. That's right.
Gotcha. Thank you very much for that. Cool. Just wanted to give a quick introduction to my services as well. So it's my name is Tyson, and I help companies 2x, 5x, and sometimes 10x their company growth. And how I can help you is I have about 3 years doing digital marketing experience. I can help you with SEO, Google Business, paid ads. I can also coach your marketing team, and I can help them with creating yearly, quarterly strategies, and also with how to create viral content and solid content marketing as well. Also for sales, it's I can help you find who your target client is, let's say how to potentially upsell them more, and also kind of making a sales plan on getting to the client, how to warm them up, and how to get them to agree to the contract. Another way I can help you increase revenue is helping you with your pricing and services. So there's new potential services you could offer. We could also optimize your pricing schemes to increase your revenue. I can also help you decrease your expenses. For example, a quote that I like to say is a company can only grow as fast as its leaders. And oftentimes, if this is your first time running a company, oftentimes you would be holding back the growth of your company because you don't know what the ideal state is. And so, based on my experience creating a medium-sized company, I can help you guide through that path and to really stop wasting time on trial and error. Like, get things done right on the first time. Don't waste months. Like, my fee is much more cost effective than spending 2 to 3 months doing trial and error each year. I can also help you with your organization. I've managed up to 5 layers, like managers, manager, manager, manager. And so I can really help you optimize your meetings, organization, and let's say departments. And also recruitment. I was able to hire 400 to 500 teachers for the cost of building a website, which was $400. So it's have a unique view of recruitment, and I can definitely help you with that and reduce your expenses there. But that's pretty much it for me. I do 2 sessions a month, 4 sessions a month, or 6 to 12. If it's 2 sessions a month, we can work on one area. 4 sessions a month, we can work on 2 areas. And anything more, we can work on more of these areas to help you grow your business. But because each of these areas takes a lot of time, it's you would have to choose 1 or 2 if you do 2 to 4 sessions a month. Cool. And that's it from my end. And yep, these are my prices. And I will send the slides later in the email. And I'm going by a little quickly just to make sure we have enough time to cover all the questions. So back to, hope you had a decent break, Iwata Sensei.
Yeah.
And let's go. So I think this kind of dives into probably Ken's question, but possibly Ken's question. But under what circumstances can a 1 year, and this is employment contract, so a worker, not a freelancer, not be renewed?
Okay, the fixed term contract must include information about the existence of renewal and the reasons for the renewal if renewed. Under Article 19 of the Labor Contract Act, a fixed term employee has a right to renew its contract even if the employer refuses, if the employee is deemed to have reasonable grounds to believe that the current contract will be renewed. Non-renewal after several times of renewal is called yatoidome in Japanese and considered to be illegal. The interpretation behind the Article 19 as to the legality of yatoidome is as follows. 1. Whether the labor is temporary or long-term in nature. 2. Number of renewals. 3. Total length of employment. 4. Manner in which the term of contract is monitored. 5. Implication of continuation of employment. So here the cases where yatoidome or non-renewal decision is not allowed. Cases where an employer didn't create an employment contract at the time of renewal, or cases where an employer created an employment contract after it renewed.
So to confirm, if the employer didn't make a contract, or it's let's see, or if the contract was made after it was renewed one time, or sorry, wait, could you state that again, please? So I think the cases where the yatoi dome or non-renewal decision, it's not
cases
allowed.
where an employer didn't create an employment contract at the time of renewal, or cases where an employer created an employment contract after it was renewed.
I see, gotcha. So yeah, if there was no contract, and the 1 year has passed, it's they cannot stop it. I see. Cool. Thank you for confirming that.
Yes.
And so I guess in what case would it be reasonable for employees to expect a renewal? Or could you go more on that point?
Okay. Concrete example is like the contract was renewed continuously to such an extent that the employee can expect its renewal automatically. The judicial courts tend to protect such expectations harbored by employees if it is reasonable. In such cases, a fixed term contract can be interpreted as similar to an indefinite term contract, and the analogy for dismissal will be applied. So I will refer to one of the options to avoid illegal yatoidome, non-renewal after several times of renewal. In order to avoid the troubles regarding yatoidome, you should include the so-called non-renewal clause, or the upper limit of the renewal times in the initial contract, as well as providing appropriate explanation as to the renewal limit.
Gotcha. So there should be a or if there's a non-renewal clause
Mm,
or the upper limit.
mm,
Gotcha. That could be used as a case where you can stop the renewal or
yes.
stop the.
Mhm.
Gotcha. But how about in the case where it's a 1-year contract, but let's say if the person didn't perform so well and you don't
Mhm.
want to renew?
Mhm. So I think it is highly possible that the contract non-renewal decisions will be permitted because there is no illegality of repetitive continuity. However, non-renewal decisions are only permitted under the situation where actual reasons for non-renewal match the reasons written in the contract, as well as their rationality and the timing to notify the non-renewal. It is said that you must notify the non-renewal more than 30 days or more before the end of the employment contract.
Gotcha. So you have to give them more than 30 days notice, and any conditions that you mentioned in the non-renewal, it must be clearly stated in the contract in advance, right?
Mhm. And the actual state and the contract content should be completely matched.
I see. So I know this is not 100, and it's like and I think if there was an issue,
Mm,
then the courts would look at the conditions to see if it's reasonable.
mm. Yes.
Okay. Thank you for confirming that. And I
Mhm.
think there's one quick question about is can would the same apply, I think if it's a 2-year contract,
Mm.
would the same rules apply?
Oh, if you set the term for 2 years, 1 year, whichever the term, and you say, it's you set the um, non-renewal clause there, it is the same, I guess. But note that you cannot set the more than 3 years contract. The upper limit of the definite term contract is 3 years, except for some reasons. But in general, it is limited to 3 years, so you cannot make it more than 3 years.
Okay. And so I think we have about 3 more questions, and I'm getting a couple questions, but Iwata Sensei will also, I'll mention if you would like to ask Iwata Sensei a question, I'll mention that at the end on how you can do that. For the next one, it's so I think if I announce to the employee, it's a let's say 260,000 yen salary, is that or is it expected that employee gets it on hand, or is that where the deductions come from? I
Generally,
think
okay.
go ahead.
Okay, generally speaking, in the case of question, it is expected that it refers to the gross amount of salary. It is often the case that foreign employers cannot understand the gross and net amount in Japanese salary system, and sometimes that brings about troubles. To avoid such troubles, you have to explain the system for the will-be employee to make them fully understand that 260,000 yen is the amount before the deductions.
So yeah, the amount expected is the gross, so the 260,000. But let's say, I mean, as long as at least when I manage a company, I think it's nice to at least give them a heads up about how much they can net,
Yes.
especially in their first and second year, because it changes. So
Mhm.
I think that's a nice thing to
Yes.
do for
Mhm.
employees.
Mhm.
For number 9, what is the minimum of days off per year that are paid
Okay.
for employees?
So there are two patterns for granting of APL, annual paid leave. I will call it APL here, according to the weekly or yearly working days and working hours. Okay. So the table shows the number of days of annual paid leave granted to so-called regular workers, the full-time workers who are required to work at least 5 days or 30 hours per week. An employer is required to grant annual paid leave of 10 working days to workers who have been employed continuously for 6 months from the day of employment and who have reported to work on at least 80% of the total working days. For each additional year of continuous service after the 6 months, an employer has to grant workers annual paid leave of the number of days corresponding to the years of continuous service given in the table. Please note that although this table is generally regarded for full-time workers, it also applies to the part-time workers who work more than 5 days a week or more than 30 hours per week. And a good example here, a worker employed on April 1st is granted 10 days for annual paid leave on October 1st of the same year. And after that, the worker is granted the applicable number of days given in the table for annual paid leave on October 1st of each year. The length of service is calculated from the day of employment, irrespective of payroll cutoff dates and work shift periods.
Okay, and I'll also show, so I think this one, they can take a look. I'm going to send our slides in the email after this session. So if you like to check the full-time and part-time, you can check it here.
Okay.
Cool.
So this, okay. Should I explain this or should I cut this?
No, I don't think you need to explain this part.
Okay, okay.
Cool. Is there anything else you'd like to mention about part-time?
Okay, so
Or about paid time off or paid annual leave.
Okay, it's not for the paid hour, right? So regarding the sick leave and late starts to office on working days, there are no specific rules in Japanese labor law regarding the sick leave and late starts to office on working days. However, the Labor Standards Act stipulates the basic principle of payroll as follows. If a worker does not provide labor, the employer is not obliged to pay wages for that portion. So it is not illegal to deduct the non-working hours from sick leave or late starts to office. Okay.
Okay. And so actually, what are some other common mistakes that business owners make?
One of the mistakes that business owners tend to make is to do things at their own discretion without confirming legitimacy. In many cases, they end up paying high price. What you've heard through the grapevine or information found on the internet are not always correct. I suppose it is necessary to obtain well-founded information, but they don't have enough time to search for and get the best answer from enormous information. I think it is a wise option to consider relying on an expert. Not only it saves your time, but also you'll get the best answer based on expertise. Another mistake that business owners tend to make is that some of them stick to the status quo and be late for improvement because of the fear of changing. In a fast-paced business environment, we are constantly forced to make changes and choices. Even though we are aware of the necessity for reforms, we sometimes step down thinking too much about effort involved in it or risks of failure.
Thank you very much for sharing. I have a question from, I think, Joe, and this is regarding contract termination.
Mhm.
And so if a contract is terminated early by the employer, may the employer be required to pay the contracted person through the end of the contract period? So I think one example would be, I'm just making this up, but there's maybe 6 months left in the contract. The company terminates the contract. Are there cases where the employer may be required to pay the remaining 6 months?
Oh, it doesn't have to be the 6 months, but it is strictly restricted to terminate the contract in between the termed contract. So it is not allowed to do that in very easily. So you have it is regarded as a breach of contract. So you have to remember it is harder for you to terminate the contract in between the termed contract than the contract which has no term, indefinite term or indefinite term contract.
So my guess is maybe, Joe, and maybe Iwata said, my guess is maybe that advice was if the company paid the remainder of the contract, it could have been something they negotiated with the person, maybe. So the person said, maybe I will resign if I can get paid for the remaining portion of the contract.
Yes.
Is that one possibility, Iwata Sensei?
Yes, I guess so.
Thank you very much. And there was one last question was, so on the graph we have, so I think for a lot of, at least, or in this case, the employee is a full-time employee. They have maybe 10 paid holidays after 6 months. And I think in the contract, 5 is determined by the company. And 5 is determined by the person. And I think the question is, can they do the same for someone who has 20 days off a year? Can they do 10-10? Or is there a limit to the amount of companies or days a company can determine?
You mean the planned annual paid leave that company designate the days for the annual paid leave?
That is correct.
Yeah. Yeah. So you have to, the law says that you have to leave at least 5 days that they can use at their own discretion. So regarding the rest of the days, you can designate.
Oh, thank you very much. Cool. Thank you very much for that. And yes, I just want to give a little introduction to Iwata Sensei and if she could help you as well. So Iwata Sensei does have 17 years of experience. She's based in Nagoya, and she has helped multiple, or she is helping multiple businesses run by foreigners with labor challenges. Some of the things she can do is helping you. She can provide legal consultation on management and also labor and social security related issues. She can also help you create rules of employment, labor contracts, and other labor documents, which we'll give some examples later. She can also help with, her firm can help with payroll calculation, processing, I think making the applications for social insurance and other types of labor procedures. Also, subsidy payment application. Is the subsidy payment, is this often like training, or what are some examples of subsidies?
Or like the one is during the coronavirus period, I applied for the subsidy for the employment adjustment subsidy for the companies for making their employees taking leaves for a while and paying them the leaves absence of leave allowance, and they are paid from the government for the portion. So this is an example of the subsidy.
Cool, thank you for that. And so for the people who have joined, thank you very much for your time joining this seminar. And Iwata Sensei can offer a free 15-minute session to business owners to discuss if she can help you on a retainer or on a one-time project. So you can go to sr-iwata.com. We'll give some clear examples for projects, but yes, sr-iwata.com, and you can send the contact form. This is also another special, so if you sign up with Iwata Sensei on a retainer contract, so a monthly contract, this is a free bonus for the listeners of the seminar. If you mention scaling your company, I get nothing in return. So just leaving that out. And it's a free diagnosis of your rules of employment if you have one. And also, she'll provide an additional free labor consultation if you become on a retainer contract up to 2 times. So about 1 hour included as a special deal. And for the retainer services, it's for under 5 employees, it's under 30,000 yen. And I think if it includes procedures and consultations, 1 to 5, it's 40,000 yen a month, and it scales as there's more employees. And for, let's say, non-retainer contract pricing, it's if you want to make rules or sub-rules in English or Japanese. Also, if you want to make a labor management agreement. These are things that Iwata Sensei can help with. I think that's the same thing. And yep, so you can, this is a QR code for her website. You can also reach out to her here. And probably preferred is you reach out through the contact form, and she can help you with retainer or also just with one-time projects. Cool. Oh, actually, Iwata Sensei does not have a LinkedIn, or Iwata Sensei, do you have a LinkedIn profile?
Oh, I don't have one.
That's good feedback though. Thank you.
Sorry.
So I got a direct message, but yeah, that's very good feedback. So yeah, that could help in the future. And thank you so much for your time, everyone. And I'll be sending this recording I'll say later this week. And I'll also be sending the slides as well, so you can see things like the labor law graph. And also, if you do hire an employee from overseas, we have that written down here. Cool. Thank you so much for your time, Iwata Sensei. I know you spent around, I think, 10 hours preparing your answers to prepare concise answers.
Yeah, it was it was good experience for me to prepare the documents for this. Yes, thank you very much for giving me the opportunity.
Thank you so much. And thank you, Aaron, for attending. And
Thank you.
Thank you.
Thank you very much.
Thank you.
have a nice day.
Have a nice day.
Great. Thank you.
Thank you.